Sir Jeremy, I believe everyone is here now. May I start with the call out?
Thank you very much.
This return hearing is in the matter of case number CFI 060-2023 and is being held by way of video conference before Justice Sir Jeremy Cooke, appearing from the UK. Any orders of directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Reed Smith, LLP. Lead counsel is Ms. Antonia Burt. The defendant is represented by Adelshaw Goddard, LLP. Lead counsel is Mr. Stephen Doherty. Will the judge and the parties representatives please confirm that the situation is as I have stated?
Confirm, thank you.
Yes, thank you.
Yes, confirmed from our side.
Thank you.
Yes, Ms. Burke.
Thank you very much for your time this morning, Your Honor. We are here today for the return hearing that was scheduled during the ex parte hearing. Since then, various correspondences between the parties took place. We have filed the claim form and particulars, and there have been quite a few developments. And as such, the situation has sort of been somewhat moving over the last couple of days. We have late last night submitted a very brief skeleton which sets out the remaining issues that we appear to be available for discussion at this stage. We are, of course, also happy to be guided by any updates from the respondent defendant with respect to its decision to apply to set aside the injunction or not, which is, one of the sort of moving parts that's outstanding at the moment, and which impacts today's discussion to some extent because we are, I think, at this stage unable to set the procedure. But subject to that, the only remaining issue that I'd like to address the correspondence is the non-compliance with the delivery up order. But we are in Your Honour's hands as to how we proceed today, and also whether it is sensible to get an update from the respondent defendant to their intention first, as to whether we then can agree the timetable or as to how we proceed.
Well, as I've read what's been provided to me, but there's a dispute as to whether or not there's been compliance. How are you proposing that dispute be dealt with?
And again, we are also in your hands and with this respect, because we have, as far as we are concerned, there is clear patent non-compliance, and I've set that out in the letter and also the skeleton briefly. So from our perspective, it is obvious that it has not been complied with. However, we have, of course, written in detail to the respondent on this issue, and the respondent has indicated that it will respond in due course. So this is again an issue that can either be dealt with once we obtain the respondent's response and potential confirmation whether it will comply with the remaining aspects that we say have not been complied with, or alternatively we can deal with this now if the court considers that this is something that can be dealt with at this stage. But we are to some extent in your hands as to how we proceed with this.
Mr. Doherty, what are you suggesting? What is in dispute, and what is the best way of proceeding to deal with any disputes?
Yes, Your Honour. Well, I think you'll probably have gathered from both Mr. Watnell's witness statement and my skeleton, which you should hopefully also have received. It has been suggested that there has been non-compliance. It's not entirely clear what the basis is. I suppose it might assist, Your Honour, if I can take you through the respondent's thought process surrounding its compliance with the order.
Well, I don't want to do that for the moment. I mean, I've read the correspondence and I've read the materials have been supplied. The real question is, what is your general approach? If you are going to simply stand on what you've said so far, so that there is no room for any further accommodation in relation to disclosure of whatever there may be, and you don't accept there are any deficiencies in the disclosure as alleged, then we'll have to make some provision for dealing with that dispute. If you're going to apply to set aside the injunction altogether, then of course we've got to make provision for that. So,
Yes.
Can you tell me, as matters stand, what the defendant's approach is?
Yes. So in terms of directions, what we were proposing was that I think the dates have probably moved slightly because things have moved since the skeleton was filed, but that by Monday we would provide the applicant and the registry with notice of whether or not we intend to make an application to set aside. And if we don't, of course, then any subsequent directions would fall aside. If we do, what I'd proposed is thereafter, within 14 days, filing in service of any evidence in support of the application, evidence and answer 14 days after that. And then if there is anything remaining to be said, evidence and reply 7 days after that. And of course, if that's the timetable, if notice is given to the registry on Monday, steps can be taken to try and fix a hearing date for as soon as possible after those directions have been complied with. As regards the, of course, the substantive particulars of claim has now been filed. We've simply suggested that that is, as it's set out in the RTC, so it'll just follow the usual timetable for filing of the defence and so on. And that will ultimately obviously need to list a CMC, but the parties, I think, will be in a position to hopefully agree to all of that in due course. As regards non-compliance, again, as I say, Your Honour, we don't accept that we haven't complied with the terms of the order. I don't know how much you want to hear the arguments about what we say about that. What we had proposed is we're going to respond to the applicant's recent letter setting out what it says is non-compliance in due course. And I think hopefully there'll be a response during the course of next week, by which time we'll know whether we're coming back for an effective return date or not.
Right. Well, in which case this is this hearing is limited in what we're going to achieve, because it's a little premature until your position is firm. It seems to me that probably the right thing to do is to make an order by consent in relation to your provision of notice by Monday of whether you wish to apply to set aside, and an order for the exchange of evidence of the kind that you've suggested, if you do make such an application. So far as the non-compliance with the order is concerned, I think it sounds as though further exchanges of correspondence may at least clarify what the issues are, whereupon if there is to be a dispute about that, it'll have to be done on the basis of evidence as opposed to merely letters, albeit that the evidence could consist of witness statements that simply cross-refers to the letters, if that's what the position is. And then this court will have to determine whether there has or there hasn't been compliance, and if so, what the impact of that is. So when are you going to respond in relation to the alleged deficiencies in the compliance with the order?
I don't know if there is a firm date. I think the intention is to get back on that next week. I know that it had been suggested in my learned friends' correspondence that whatever deficiency they had identified be remedied by the 18th. I would hope that we would be in a position at the time we're notifying of our intention on the set-aside application to at least provide an update at that juncture. but I might have to take instructions on the precise timing. But I would expect them to have notice of our position next week.
Yes. All right. Well, it may be premature to make any orders in relation to that for the moment until the position's crystallised. As it happens, I shall be in Dubai next week, so that I can liaise with the court staff, as long as you keep in touch with the court and tell the court what's going on.
Yes.
Ms. Burt, in the light of what's been said by Mr. Doherty, do you want to make any submissions as to what you say should happen next?
Thank you for the opportunity. We agree that the hearing is somewhat premature in light of the developments that happened, and of course we need to know whether the injunction will be, whether there will be an application to set it aside or not, and whether they will have any comments on non-compliance or any further attempted compliance. So in that respect, we agree that the best way forward may be to defer these issues until next week. Obviously, the sooner the better. And then at that stage, I do hope that we can agree consent order. We have already agreed with respect to the procedural deadlines for both eventualities. So that is agreeable. And as Your Honor has directed with respect to the non-compliance, that also is all agreeable in the sense that once the issues are crystallized, we can submit evidence on this issue. And if the respondent is going to apply to set aside the injunction, that I imagine the evidence can be submitted with the set aside application and potentially heard at the same time. Whereas, of course, if the respondent decides not to set aside the injunction, then we are in a slightly strange situation where we may need to have an additional application with respect to non-compliance. And to consider, of course, whether Your Honor will hear that orally or decided on papers. But I think that's the position we're in at the moment in terms of next steps.
Yes. All right. Well, you're agreed on the procedure in relation to any potential application to set aside, as I understand it. So that's by consent by Monday, which is the 18th, is it?
Yes.
Yeah, by Monday,
yes,
Monday the 18th, the defendants will notify the claimants whether they wish to apply to set aside, and then you've got a timetable that's already agreed, have you, in relation to exchange of evidence, 14 days and 7?
Agreed.
Okay. And obviously a hearing date to follow from that as soon as possible thereafter. I think then in relation to the question of non-compliance, it should be a term of the order that you update the court by close of business on Wednesday of next week. That'll be the 20th, as to what the current state of play is on that. And at the end of the day, Ms. Bird, it'll be up to you whether you want to take out an application to say that there's been a breach of the order. And when you do that, is a matter for you in the light of whatever further compliance or refusal to comply there is in your perception. But I think that's about as far as we can take it today, isn't it, Ms. Bird?
Yes, thank you. No, that's understood, and thank you for the guidance. The only final remaining issue is, of course, the continuation of the current interim injunction.
Yes.
So that's the because of course the existing injunction was stated the return date of today. So that's the only other additional issue. We have provided a continuation order, which is very similar to the initial order, but we've sort of deleted the aspects that have already, where the dates have already expired to some extent, or aspects that have already been done. But otherwise, it is very much the same order. So we have put this before you, Your Honour.
Yes, Mr. Doherty, you any comments about that?
I think only one, Your Honour, slightly in your hands. It's simply as to whether or not one ought to include the respondents' reservations in the recitals, i.e. that by making the continuation order today, the respondent still has open to it should it decide to make an application to set aside.
Well,
The various arguments open to it.
Yeah, I did. You know, I think that stands. You know, you've made your position plain. Your rights are reserved in relation to it. I don't think we need a recital as such, but should you wish to apply to set it aside, you can do that, and we'll see where we get to. All right.
Okay.
Well, in which case the order can be made in those terms for the continuation of the injunction as drafted. And if you would agree between you the form of the order relating to the procedure that we've just outlined, so much the better, and sign up on it and send it to the court for its approval, please. All right.
Yeah, grateful, Your Honour. Thank you.
Anything else?
Nothing from our side. Thank you very much for your time.
I do believe so, Your Honour. Thank you.
Very good. Thank you very much. If you would all like to sign out, I'll have a quick word with the associate. Thank you. Oh, one more thing. Well, it's one more thing. There appear now to be two case references on this, CFI 060 and CFI 063. One is a part 7, one is a part 8. Is the simple answer to have an order that consolidates the two?
Yes, apologies. I should have updated you earlier, but we have already agreed with the other side to consolidate. So I assume that the earlier case number will be assigned once it's consolidated, and we will obviously include that in the consent order.
Yes, well, let's put that in the order so that there's no confusion, because I couldn't get into the hearing for a bit until I realised there was another case number that I needed to be looking at. Let's avoid any confusion by having that firmly set out in the order. All right.
Thank you.
Thank you very much. If you would like to sign out.
Thank you very much.
Thank you, Your Honour.